The last case of the day is People versus Lee. Like every other case today, this is an argument on the application. You have 15 minutes. You can reserve a reasonable amount of time. Please try and keep track of it, because we obviously aren't good at that.
Thank you. Good afternoon. May it please the Court, Anna Quiros, on behalf of the people of the state of Michigan, I'd like to reserve 2 minutes if I have anything left over. Thank you. In support of our argument, the people want to make 2 points clear. The evidence was sufficient to prove that the defendant in this case committed an affirmative act when he removed himself from the home, left the child alone with Smith, whom he knew had recently sexually penetrated this child. These facts show that the people have met their burden under subsection B of the child abuse statute. The second point I want to make is the child abuse statute does not define or limit the definition of the term act. The Penal Code in section 750.10 specifically states that the term act or doing of an act includes the omission to act. For these reasons, the evidence was sufficient to prove that element of the offense. Opposing counsel argues that subsection A's narrow use of the term omission means that no other form of omission can be charged under any other subsection of the statute. This is a misinterpretation of the law. This would mean that if Smith had chosen and this defendant had chosen to sit in the same room and watch Smith rape this child and the defendant have done nothing about it, that would not be a violation of the statute. That would result in this Court of Appeals, or the Court of Appeals opinion in this case, which held that no matter how many times this child complained to his guardian that the guardian's boyfriend was raping him, the guardian's decision to do nothing to protect the child was not a violation of the statute. We are not asking this court to overturn we are asking this court to overturn the Court of Appeals opinion, but based on the statute as written, that shows that the evidence was sufficient to prove that the defendant in this case committed an act under the statute. I'd welcome any questions.
I just have a question about how a reviewing court evaluates an argument like this. The trial prosecutor in this case argued that it was an omission. I understand you have articulated a clear act, and I hear you, and I think there's force to that. But I'm just trying to understand how we think about our standard of review. So if the trial prosecutor argues under second degree that the defendant's omission is the actus reus that satisfies the statute, and then in the Court of Appeals, the same argument was made, it looks to me, from looking at the briefs, and so the Court of Appeals, in responding to that argument, says that's not satisfactory under the statute, and then in your application here, that was the same argument that was made. But I know the reviewing standard is supposed to be extremely deferential.
Correct.
And if there's any, evidence in the record, was it the Court of Appeals' job to say, all right, the trial prosecutor made a dumb argument, didn't make the best argument, and you haven't made the best argument in your brief or to us, but we have a responsibility as the Court of Appeals to go look at the record and find whether there's evidence from which a reasonable juror could convict. Is that what the Court of Appeals should have done?
Well, I think that if you do look back at the record, and I'm going to point to...
And even look back at the record to support an argument that the parties haven't made?
And I've quoted the prosecutor's closing argument in my brief, in my supplemental brief. And in page of the appendix 260 through 261, I quoted the prosecutor's analogy, where she ended the analogy by saying this is the exact same case we have here. And her analogy was, now you have to remember there was aiding and abetting count against this defendant for the criminal sexual conduct. And in that, the argument was under aiding and abetting, the defendant failed to protect the child. every time the prosecutor spoke about the child abuse statute, she always referred, and the judge always referred to an act. And the prosecutor's analogy in her closing argument was, what if this was a 7-year-old girl who has a mother who is just fine, a good mother. The mother's boyfriend moves in. The mother's boyfriend starts to rape the child. And then the child says to the mother, this is happening. And the mother does nothing to protect the child. And then the mother leaves the child. And to quote the prosecutor, she leaves the child alone with her boyfriend, and lo and behold, another sexual assault occurs. And then she ends by saying that leaving her boyfriend home alone with the child so that the rape can occur again, well, that is what we have in this case here. And that she was arguing the same facts to support the aiding and abetting under the theory of the criminal sexual conduct count, and she was arguing that an act occurred. We are arguing the same thing. An act occurred, an affirmative act occurred when he removed himself from the home. And again, I know that this court, in the earlier argument we talked about Barome, was Smith a hungry lion? Was he dangerous? How many times, and also to answer Justice Bernstein's question from the earlier argument, how many times does a child have to be raped and complain about the rape before somebody is put on notice that they should protect this child? And I argue once. Once is enough. A reasonable trier of fact can find under these circumstances that the defendant was placed on notice that he had to protect the child. And in order for you to find that I am wrong, in order for you to uphold the Court of Appeals' opinion in this case, you have to find that 750-10 does not apply. The 750-10, the broader definition of act, does not apply. And there's nothing in this child abuse statute that overrides the broader term of act. So I would ask you to overturn that opinion.
Thank you, counsel. Would you like to reserve some time?
Yes, thank you.
Good afternoon, Your Honors. May it please the Court. Jason Eggert from the State Appellate Defender Office on behalf of Mr. Lee, and I'd waive any free fire zone here. This Court should deny leave here. The Court of Appeals' application of the second-degree statute was a straightforward application of the plain language that statute has. The reason for this is clear when you look at what the statute says. Mr. Lee's failure to prevent harm to a child is simply not covered under the statute. We know that because the statute defines what omissions are covered. And those are limited to the failure to provide food, clothing, or shelter necessary for the child's welfare. A general duty to prevent harm is simply not part of that. If the legislature wants to have that type of thing covered, it can do that. That's something that has happened before when this court has done.
Could an act be inviting this individual into the home?
Well, I think in this instance, he was in the home, and then an act occurred later.
I understand, but could an act be that you allowed this person to come into the home in the first place? Whether or not you knew the circumstance or situation, could the act be that you allowed the person entrance in?
Certainly that can be an act standing on its own and inviting someone to your house.
No, I mean, coming in this situation, they came to live. They came to reside in the property. I guess my question is, it's just hard to understand exactly when you're talking about an act. Can an act be the initial invitation to come and live in the home as the guardian did with this situation?
Well, here, no. At the time Mr. Smith starts to live with Mr. Lee and his nephew, he has no understanding, no knowledge that there is a problem there. So him just being invited to the home standing on its own is not an act that can be used here to convict Mr. Lee of second-degree child abuse. And I think part of the reason we have this confusion is that there's obviously, I think, applying the prosecutor's approach, it turns the distinction between omissions and acts on its head. For example, if you look at the omissions we have covered here, the act could be for a failure to provide food is that someone went to the casino and spent money instead of giving food to their kids, then now we have an act of going to the casino.
But that's sort of that problem exists in all act omission dichotomy and all criminal law, and it's like age old, and we teach it for a full 10 days in criminal law, and we've decided that mostly we leave it to the discretion of prosecutors. What about the act of leaving the house once the defendant was already on notice that the child had been raped, and now the prosecutor argues that the act of leaving the house satisfies sub B. What's your answer to that?
Well, I think we have a couple reasons that's not sufficient here. First is that although this proved to be not a sufficient protection here, is that Mr. Lee confronted Mr. Smith after the first allegation. When we look at the testimony, it's obvious that he thought that would be sufficient based on his reaction the second time this occurred, which was to immediately contact his nephew's biological father and have the police contacted, and now we're here. Second, it's again, we're shifting the focus away from what's the duty here. The duty, we have a duty to prevent harm. When duties come into play, that's when we're looking at omissions. And that's significant here because although there is this general definition in the statute, what we have here is the legislature telling us specifically that omissions mean these three things in the statute. And when you read the provisions together, it becomes clear that it's only limited, that you can't import all other omissions to fall into the act category. That's why they delineate certain things like a knowing and or intentional act, a cruel act, or a reckless act. And that's why a general duty to prevent harm doesn't fall within the scope of the second-degree statute.
No, I know, but that's why I was asking whether the act, don't call it an omission anymore. I understand that's how it was argued to the jury. I understand that's how it was argued to the Court of Appeals. And putting aside my questions of how we review all that just for now, if the prosecutor had argued at trial that when he left the house, that was an act that knowingly or intentionally was likely to result in was likely to cause serious physical or mental harm, would that have been a sufficient theory?
No. And the reason for that is, partially what I described before is that Mr. Lee did confront Mr. Smith.
So on the facts, as applied, you don't think it would?
It does not. And that's something I've argued in my brief, is that if this leaving the home is to be considered an act at all, this falls under the definition of reckless acts, which the prosecutor had the option of charging and chose not to. It's simply not sufficient here to show that when Mr. Lee left the home, he did so either knowing, it didn't make it practically certain that because this happened before, that it's going to happen again when he chooses to leave his own home. We have options here for prosecutors when they look at certain cases like this. If leaving the home is an act at all, then you're looking at reckless acts, and that's not sufficient to prove that he knowingly or intentionally committed an act here that was likely to cause serious physical or mental harm, which is when you look at, it doesn't require that harm actually occur, but the harm, I think, is significant here in the definition in that it's very severe injuries that are listed in the definition of serious physical harm. And that's why I think it's insufficient here to prove that Mr. Lee had that type of knowledge when, after confronting Mr. Smith about that, he decided to leave his own home.
Any other questions?
Okay.
Well, thank you, counsel.
Thank you.
You might be the only person who successfully reserved time.
Thank you.
Congratulations.
Thank you. I only have a couple of points I'd like to make in rebuttal. And I think that what's really important is to point out that the statute says that likely to cause serious harm, not as counsel has stated. And is it likely? Likely can be the same thing as significant chance that that there will be a reoccurrence of the rape. And I think that a reasonable juror could find that it was likely that the defendant or Smith would reoffend when left alone with the child. And the other point I'd like to make is that I don't think there should be any question that serious mental harm, which is defined as an impairment to behavior or ability to cope, is a juror could find that that would be the result of being raped. So in those senses, those are the 2 points I'd like to make. I also want to point the court to a couple of spots in the transcript that talk about, really, if you look at the whole transcript, that these 2 rapes occurred within 2 weeks. Smith moved in January 29th. Both rapes occurred while the child was 14. That was his testimony. The child turned 15 on February 13th. So both rapes occurred in a small period of time, which heightens the notice to this defendant that this is a dangerous man.
And that's enough to get us to, when he left the house, he did it knowingly or intentionally to cause that result? It's not just knowingly or intentionally left the house, right?
Right.
He had to knowingly or intentionally.
I'm arguing that he knowingly left the house with the information that he had. He knew that Smith was a dangerous person. He knew that Smith had recently sexually penetrated the child, and he left the house knowing that it was likely that this would reoffend, that he would reoffend. And I think that's reasonable for a trier of fact to find.
Thank you, counsel.
Thank
The case
you.
will be submitted. And that's the end of our case call for today. We stand in adjournment until tomorrow morning.